Welcome, everybody. Those of you here in person, remember that asking a question is not an interruption. Asking a question, any kind of a question about paralegal studies, even if you're afraid it might be off topic, it probably isn't. I love to have just included in what we're doing. Answering your questions is more important than having just a run through of my slides. So go ahead and ask any question about paralegal studies, especially, of course, about torts. Background information are good questions. So you say, well, what's the background? How would we apply this? What have you experienced? Anything like that is fine. Basically, the only bad question is one you were too shy to ask. So go ahead and ask it. In other words, a bad question was one that you should have asked but didn't, put it that way. So go ahead and ask. If you are listening by recording, of course, you got a little bit more work to do to ask a question. But if you're listening by recording, what do? You just send it in by course messaging, and then I will answer it. And if I can't answer it now, or if it requires screen sharing, a little bit of extra work, I'll do it on Monday. Excuse me, it's not Monday, is it? Tuesday, I believe. Okay. Let me check that out here. Did I schedule it for Tuesday? I think so. The next session is coming up fast, but this first half week, yeah, 7:30 p.m. Tuesday. Central Daylight Time. So I often encourage people, try to come up with one question before the session, maybe one question during the session. When I listen to other lawyers talk, when I attend further education, one of the methods I use to increase my concentration level is to write down at least 2 questions. Hopefully the questions have something to do with the content, but either way, I will be listening for the answers to the question. If I don't hear it, I talk to the presenter, either during the session or after the session. I do talk to the presenter. Why do I do that? It's because lawyers don't like to listen to other lawyers, so actually we need helps with focus power. And of course, you may be wildly enthusiastic about listening to me, and that's fine, but you all have stuff in your lives going on. And anything that adds to your focus power will help you succeed much more easily. So write down 1 or 2 questions as soon as you can during the session, before the session, and so on, and then ask away. Sometimes I go through things too slow, sometimes too fast. Your individual needs count. For instance, if you miss something about the elements of negligence, asking me to repeat it is really smart. Same thing with the reasonable person concept. Some of these things are so kind of commonsensical in a way that they're hard to even explain. Some Latin terms are actually easy because you always look them up and you don't really think you know them. Some things like negligence, we think we know it so thoroughly from just common use of the term negligence that maybe we don't really know it. And so we need to actually study it. Reasonable person. Who knows a reasonable person other than yourself? You know reasonable people. Yeah, friends, okay. Yeah, and a better question would have been name some reasonable people or by person or category, name or category. Okay. So reasonable people, what do reasonable people do? Yeah, that's fine, Tia. Tia's just asking a procedural question. That's not disturbing at all. Remind me that if something is in the chat too, if you ask a question about torts that I need to answer, I probably need to read the question out loud so the recording gets it. But the reasonable person concept, it basically means that you evaluate things, evaluate fault as a reasonable person would. But of course, reasonable person is never fully defined in the law. It can't be. We have to trust that judges of trial courts know who reasonable people are and how they act. It's almost easier to define unreasonable people. And you don't have to give me names, but who knows an unreasonable person that would not make a sound decision about something like fault or duties? An unreasonable person. What might be a characteristic of an unreasonable person? How does an unreasonable person deal with facts? Might be easier to look at it that way in some way. A reasonable person does not act like those unreasonable people. Unreasonable people, yeah. Not accepting their wrongs and blaming others. And then, of course, even if it's something that they should be able to understand because it doesn't involve them, they overly personalize even something like that. If they were on the jury, would you trust them? Even it has nothing to do with them. They're a juror, and they're not even allowed on the jury if it has anything to do with them personally, but they would still find some way to overly personalize it, right? Tia's bringing that up. Tia brought up accepting their wrongs, blaming others. Yeah. If so a reasonable person is able to accept the facts more or less as they are and try to evaluate it using common sense, knowledge, and taking things that should be taken at face value as face value. They're not trying to read into things in some strange way that doesn't make sense, okay? Res ipsa loquitur, that means the thing itself speaks, which is literally Latin, but that's not really the legal concept. A res is a thing. If we were ancient Romans, we'd say, well, anything is a race. A chair, a step. If somebody stepped on a rotten step that was made out of wood and fell, and we could see the blood of their knee on a higher step, and we could see that the rotten boards would break, would it be reasonable to draw the conclusion that the person stepped on the rotten step, which appears to be broken, and hurt their knee? The knee is bleeding and there's a blood on an upper step. Would that be reasonable to think that the person was proceeding upstairs, fell through the rotten step, and hurt their knee on one of the upper steps? Is that reasonable? Is the object, the steps, is that telling us something without needing an eyewitness? What do you think? What are the steps telling us? In other words, you just have some photos of the steps, or you as a jury are brought to see the steps, and you can see what happened by looking at the steps. How does that clarify the concept of res ipsa loquitur, which lawyers often call res ipsa? The case of the broken steps, which is different than our case. Our case is slip and fall on a floor, not a step. I'm not seeing anything in the chat. I'm not hearing anything. Nobody's unmuting. Help me out here, please. Tort definition, 3 bases of torts. Intentional tort, if you had a child on the playground and they came to you and they said, they meant it. They meant to hit me. Yes, they did. And you say, no, it was an accident. If your child already knows the difference between being careless and intentional, if you have a grade school kid. Okay. Make sense so far? Where are we on these types? Maybe my sound's off? Okay. Oh, it is making sense. I see a bunch of yeses. Okay. Who has grade school age child that would understand the difference between, the rough difference between intentional torts? Of course, I don't know the details necessarily with the lawsuit, but the basic difference here, children know this. Who has a child that would know the difference between he or she did it on purpose and he or she was not very careful? Okay. Strict liability is a strange thing. It's just, if you look at it a certain way, it's just an easier to prove tort than negligence, but otherwise the same as negligence. And we'll get into that more later. Well, basically, negligence is based on something called due care. Due care as a what? Reasonable what? Reasonable person would use. Avoid negligence, okay? But strict liability, if you built a fireworks factory, you would have to basically make sure no harm comes from it. So greater duty than due care. So the more hazardous things that you do, the more likely you are to be held by strict liability. You say, well, so I would never start a fireworks factory. I would never even build fireworks because how can you guarantee that you're not going to create harm? That seems way too much. And of course, there are defenses even to strict liability, and we'll go into that later. Tort system does not work for everyone. And this is right from the lesson content. As this, okay? Now slow me down, speed me up, ask me a question, please, as I go. Outline of civil litigation. Most of you maybe have not had civil litigation yet, not sure. Who has had civil litigation? Just put CL in the chat so I don't, okay, I have, that works, okay. So what we're working on this time is pretrial. And I'm going to tell you in advance that many lawyers do these wrong and partially wrong. And I'm being overly critical partly because it helps. I'm sort of leaning over. I'm being a little bit overly critical due to memory issues. You can certainly come back later after you've taken the class and say, well, Mr. Olson exaggerated some stuff about the way you ask interrogatory questions. Lots of lawyers get by doing that. Well, true, they do get by with it, but they don't get all the information they could if they ask proper questions. Everybody has done this wrong at some time that's been in litigation. They've asked the wrong question in the wrong place. They've asked something in interrogatories that should have been asked for production of documents. Julie has taken civil litigation, so you know where I'm at somewhat here. Well, you probably totally know where I'm at, but they have asked things in interrogatories that should have been asked in something called request for admission. Many lawyers have forgotten that there is such a thing for request for admission, so they put them in and they waste an interrogatory on it. I don't agree with that. Don't waste an interrogatory on something that's a request for admission. We'll deal with that. But a request for admission is a yes-no question that's very distinct from the interrogatories we're going to work on. Requests for admission are very useful, and I have advocated it with lawyers. Use them. If something is obvious and should be admitted, but the other side won't sign for it, won't sign an agreement for it, request an admission. But we are not at all doing that this week. An admission is a yes or no. Never do those, and I'm going to repeat myself on this. Yes or no questions for interrogatories. Don't ever do that. If the lawyer insists on that, fine, you know. I'm going to skip ahead here. And we'll go back. I'm just giving the code word. And I'll be right back to the other thing. I'm going to give the code word early in the session. Sometimes I give it later. It's just the word negligence. Here we go. Negligence, duty, breach of duty, actual cause, proximate cause, and harm. Duty, what you're supposed to do. Breach of duty is you didn't do it. Actual cause is proof that breach of duty caused the harm. Well, caused the, well, basically caused the harm, yeah. And proximate cause is that the harm was reasonably foreseeable, which is kind of a big concept, but if you have people going up and down steps, if you have people going up and down steps, it's reasonably foreseeable, and I will get to that, Desmond, by the way, that somebody's going to get hurt, probably somebody walking on the steps. But it's also reasonably foreseeable that one person walking on the step could hurt somebody else that's about to walk onto the step that falls into them, or somebody that's on an upper step. So it's foreseeable that 2 or 3 people could get hurt due to one bad step. It's also foreseeable that a pet could get hurt. Somebody's carrying a pet. You see where I'm coming from? And then we're going to backtrack a little bit. Actually, we're going to go over that again, but never do yes or no questions for interrogatories. Do not. We are not going to do those here. Lawyers do them, and the reason they do them is maybe because they think they've got plenty of interrogatories to use. Maybe they're not that familiar with civil litigation. They don't know that there's a limit to the number of interrogatories you can ask in most states or in the federal court. So they ask questions that should have been asked elsewhere. There should have been a request for admission, or they're asking a yes-no question that's preliminary that you don't have to ask at all. For instance, I asked somebody, who were the witnesses to this matter? List all witnesses, names and addresses, and so on. Do I have to first ask, were there any witnesses? Yes or no? No, I don't. Do you see where I'm coming from, folks? I don't have to ask that. If there weren't any, they'll say, there were none. Okay. You don't have to ask a preliminary yes or no question in order to get permission to ask the question. The other one, what documents did you keep regarding this matter over the last year? If the answer was no documents, that's their problem to tell you no documents. You don't have to say, you don't have to first ask, were there any documents about your practices, your safety practices? You don't have to ask them that. Just ask them for their documents. What documents did you keep? Of course, technically, we don't ask for the documents in the interrogatories. We ask for them in a different discovery thing, but we can ask in an interrogatory what documents were kept for your safety practices, whether in your manual or otherwise. You know, we can ask them a what question. The written assignment has to do with Thomas Jones suing Al's Groceries. One advantage of having been a general practitioner is I have sympathy for both sides. I've had clients that were like Thomas Jones. I've had clients that were like Al's Groceries. Okay. So I kind of understand both sides, kind of have some sympathy for both sides. So it's kind of an advantage. You can go to Lexis Advanced for slip and fall cases. We are going to create interrogatories. When the assignment says create interrogatories, I take that literally. You create them, you don't copy them. Someone else's. why don't I want you to just find and copy somebody else's perfect question? Somebody who's had me before can answer this, or anybody can answer this. Why don't I care about a perfect one that you found? Any guesses? Well, what's the educational advantage of copy and paste? Yeah, T is right. I want you to use the sample one for formatting, but I'd like you to do your own questions, but do not do auto accident ones. There was no car in Al's Groceries. Yeah, do your own questions, but use the formatting. Yeah, Desmond brought up that's what he wants to do is use the formatting. That's exactly what I want. I'm agreeing with Desmond. Thank you. Yeah, you are correct. Use it for formatting. But I would like your own stuff. I'm gonna skip ahead of what is a tort right now because I'm really heavily into this. Actually, no, I'm not. I'm gonna back up and say what a tort is. This is right from page 9. I guess what I'm gonna suggest is that you really read page 9. Civil wrongs other than a breach of contract. Money damages are the remedy for the person wronged. So really, interesting the way that they define it. But look at page 9 just to get an overview of torts. It's not, a tort is not one or two different things. It's lots of different things could become torts if it's a civil wrong. It's kind of odd, but most torts that we sue on, though, come under negligence because negligence is covered by insurance. Insurance pays. There's some way of collecting the money if you win. So that's where people sue. People also sue people with assets, too, for some other matters that are not insurable. But negligence, basically carelessness. Failure to use the care that a reasonably prudent person, again, reasonable person, prudent person just means a reasonably careful person. Would a reasonably prudent person try to weave around driving 90 on a highway where the speed limit is 45? What do you think? I'm just kind of make sure that you are working on it. I'd say no, but you could say yes, of course. Breach of duty, physical causation, proximate cause harm, money for harm. In theory, a slip and fall could be caused by intentional pushing, but the reality of lawsuits is what? Negligence. Who is likely to be sued? Negligent people with insurance. What steps should businesses do to limit harm and limit the money they lose? Well, they need what? What do they need? They need a plan. What else? You're running a store. You have a written plan. What else do you do? Anybody? Everybody? Amongst the choices, training, demonstration, get insurance. Yeah, get insurance is up there on the chat board. Would you have signs available for hazardous conditions if there was a temporary hazardous condition? Would you buy one of those mops that has a sign saying wet floor? You know, that kind of a thing. Would you have a way to mark off if there was a problem with one of the entrances? Would you have a way to mark that off? Yeah, you would do things like that. You will be completing a set of interrogatories for the written assignment, slip and fall case. A research on slip and fall. You are from all states. You want to have an understanding of what constitutes a slip and fall. You absolutely need to make them open-ended questions. What's an open-ended question versus a closed-ended? Open-ended, they have to give you new information. You're not asking them to confirm or deny information. Open-ended asks them for information that you don't have. That's the purpose of interrogatories. It's not to confirm or deny stuff you already know. Okay. You can do more than required. I guess I'll take a look and make sure what's required. I don't think you're required to do that many. Let's see. At least 10, it says. You may do more. I'm a good skimmer. Once you gain the points, you don't lose them. But if you ask a bunch of yes, no's, you know I don't like them, put them at the bottom, okay? Put the 10 good ones up on top. And the individualized ones. If you want to have some, you know, the yes, no's and the canned ones you found, put those at the very bottom because those don't earn any points to speak of, probably none. And so put the good ones. The good ones are not really good in the sense of perfect. I don't want perfect. I want new stuff. I put that at the very top of your list. Don't worry about perfect, but that will drive most of your classmates into silly use of somebody else's product, but teaches you nothing. How long would it take a smart fifth grader to type in interrogatories in a Google search and copy and paste? About 8 seconds. And of course, you wouldn't do that, but it'll look about the same as, frankly, it looks about the same as one of my diligent students doing the same thing and then looking over lots of choices and, oh, well, you know, you look at lots of choices. But if you copy and paste, it looks like fifth grade work, even though all of the questions are perfect and were done by lawyers. So don't do that thing. What I want you to do is use the journalist's friends. Who, what, when, where, how, and sometimes why. Any question you ask, starting with those words, will advance your skills. Again, there are no dumb questions. You can ask for a list of names, and you say, well, that seems like a dumb question. I asked for a list of names of people who work in the store or something like that. That's not a dumb question. That's a wonderful question. Some of the ones that you think were too simplistic are actually the best ones, and I don't know why some lawyers don't ask them. They end up having to investigate themselves because they forget to ask the other side the simple, ordinary questions. Now, do they all have to be in question form? No. You can demand a list of something. You can demand a list of employees, including those that were there and that were not there at the time of the accident. There are I do have some good and bad choices that I've listed here, and I put the bad ones. I explained the bad ones. So don't do this. Were you at the premises at 9 a.m. on January 3rd, 2020? People love those because they're on lawyer shows in trial stuff. So don't ever do that with interrogatories. Those are confirm or denies. It works for crime shows where they're cross-examining. They can't ask their own witness that, but they can ask an adverse witness that. But we're not doing that. We're trying to find new information. In legal work, the other side's lawyer will chuckle because if they didn't arrive till 9:10 a.m., they can just say no. You lose. You ask them to confirm or deny 9 a.m., and they got to say no. You received zero information. Then you have to get permission from the judge to ask a follow-up question. Then you hopefully get it right. Maybe the judge says, well, you've already used all of the questions that we're supposed to use in a state, and if you want to learn more, you'll have to use some other method. Not my problem if you want to do that. You people are malpracticing. The judge may just be a tough judge. But in casual conversation, you can get by with yes-no questions. In law, you can't, because in a civil lawsuit, you can't force somebody to volunteer information. They only have to answer your question. Don't use canned ones, zero educational value. Don't use ones you have used in a job. You're here to advance. You're drafting your own questions. So true, when it's a standard case in a personal injury lawyer's firm, you're going to end up using lots of canned questions in a sense. They weren't canned questions when they were first asked. They kind of are now. But what if an unusual case happens that's different than anyone that's been handled before by you or your lawyer that you work for? You'll be able to come up with the journalist's friends, who, what, when, where, how, and sometimes why. You'll be able to ask these so-called obvious questions that nobody asks. It's one problem I would say with being a parent. When we're parents, we get used to asking all these yes-no questions, and we kind of can figure out if they're evading us, not asking, but we're doing it in person, aren't we? When you do it by sending an interrogatory, and ask, were you in the premises at 9 a.m.? They say no. We don't know that they're hiding information, but of course they can take it literally. If we ask our child, were you out after 10 p.m. At Johnny's house? Or did you mind the babysitter or something like that? They might say yes or no to something or whatever, and but we know that they should be giving us more information. But when you do that in legal work, it doesn't work. So in a way, you get into bad habits when you're on questions when you're a parent, because you tend to ask a lot of yes-nos. Any poorly phrased and overly general question you draft is better than a perfect one somebody else created. The example, I guess I told you that, but this one is a demand type, and this is acceptable as long as it's your writing. acceptable, even though not actually a question. I'd rather have you simplify it though. You can always use formats or you can always use pre-used questions that the lawyer has when you're in practice. But in school, I want you to come up with your own simplified ones, and you and the lawyer can always put them back into legalese if needed, okay? But this is your chance to just think for yourself totally, good and bad. When did the fall happen? Good one. So that one's good. Much better than did the fall occur at 4 p.m. If it occurred at 4:10 p.m., they get to say no. So we don't want that, okay? Who was present? That's good. John, Dave, Mary, and Joan were the only ones present, correct? Bad. And we don't ask a preliminary question like, was anyone present? If so, whatever. You're wasting a question. Most judges would say you already asked. That's one of your numbered questions. Maybe your question, there was a question about numbers. In some states, you can ask quite a few, but let's say that they let you ask 30. The lawyer is always going to have a 31st question that they wished they could ask, but we ruined it by asking, was anyone present? Bunk. List the people present. If the answer is none, they'll answer none. That's their deal. Why did the store do this? What was the condition of the floor? Simple questions. How did you respond to is much better than did you render first aid or assist the plaintiff. We don't ask them yes, no's. No yes, no's. 0, 0, 0 yes, no's. Ask them when, who, what, how, why. I left out where, didn't I? Where in the store was checkpoint. How are you doing with this? How is this working for you? I really want you, I guess the other thing is enjoy breaking the habit. I would really, really, really like you to have fun with this. And I've sort of laid it on the line, and I've used kind of a tough tone of voice, but the purpose isn't to be tough. The purpose is to be more business creative, new things, new questions, and then have more enjoyment. Not in a rush to formally use questions. Yeah, in the rush world of law office, a lot of times you're going to use formally used questions, but we're going to do we're doing something a little higher level, a little more of a brain work, but enjoy it. Yeah, and your time was not wasted. I've got a question about yes, no. Your time was not wasted because sooner or later you will be able to persuade the lawyer you work for, whoever you work for, to use those yes, no's in the other format, in the request for admission. There is a place for that. Then lawyers do not use request for admission as they should, and you can help with that. But just don't do it for this class, okay? You might want to save them and relabel them for your portfolio, personal portfolio. If you already did some, save and relabel them request for admission, okay? I mean, a good admission is simply sometimes to some things that both parties know, you absolutely know it to be true, both parties know. For instance, if there was a certain situation, it's photographed, the photographs were taken right after the incident, there's bills that everybody knows are true bills because we gave them access so they could double check the bills themselves. You know that those are bills or invoices that are a result of the accident. Everybody knows it, but they haven't, for some reason, the lawyer on the other side will not sign an agreement called a stipulation that those are a good list of bills that can go into the court that can be admitted. And those photographs, they haven't really admitted that those photographs are legitimate or whatever. We can ask them to admit, request for admission. But in this situation, of course, we want new information. New. You're already into the discussion, and I don't think you're having any real problems with it. But one difference, I want you, even if you end up citing the case itself, get in the habit of getting all the discussion points. Interact with a starter post and at least one reply. By Saturday, 11:59 p.m. Okay? And how do you get the rest of the points? Use and cite at least one source. And here they already gave you a source. If you don't have another source, find the site for this, okay? My grandson just came, so hi, Walker. Zone of danger is kind of interesting. So you have an accident way over here, and it knocks something down way over here that falls on Helen. And they had no idea when they were trying to get this guy into the rail car that he had a package that was going to create a problem way over here to Helen. So they are kind of, the judges are saying that Helen was not really in the zone of danger. Other people say, yes, she was. In today's world, I think they would say that fireworks put everybody in the zone of danger, and that railroads should keep fireworks off of passenger compartments or all of their property. They shouldn't allow any fireworks on their property. Do you see where I'm coming from? I'm afraid it would be very expanded now, but it's still used as a case because of general purposes, general legal principles is why it's used. Not because explosives are okay. On trains, buses, or planes, okay? You got to realize, way back in time, there was more individual responsibility and less corporate responsibility, put it that way. Kind of strange, huh? One of the things we're talking about this week is how do you create the law of torts? It's really strange that torts is the way it is because we expect it to be in the state statutes made by the legislature, but hardly ever is it. Only a few things are actually in the state legislature's work of statutes. Most of it's all old case law. That's why you're looking at some very old case law. Well, we updated it a little bit to 1981. I looked this up in Lexis. How did I find a case that explains modern interpretation? I went through Lexis, and I went to the original case, the Palsgraf case, and then I looked over to the right, and I thought, well, I'm going to look at one of the caution cases. And what did I come up with is this one. This one looked like it would help, and it does help. It helps explain it. It starts to make more sense. Palsgraf has never really been overruled. It was not appealed to the U.S. Supreme Court. The Court of Appeals of New York is not called the Supreme Court. Supreme Court in New York is not the highest court. Court of Appeals is. So the general principles are still the law of New York State, but not the exact application. Does that make sense? But a lot of the application is changed due more to, that's where people like national federal authorities, interstate transportation, and state authorities that regulate any passenger outfit, that's where regulations and statutes create greater duties than they had in the past. I'm sure if you researched it enough, you'd find out that the legislature authorized the transportation authorities in New York State to have rules on how people's baggage needs to be checked, or the rules that have to be posted or on the ticket before they become a passenger of anything like bus, railroad, or plane. And then being as and transportation also crosses state lines, there are also federal regulations on this. So I wouldn't be afraid that somebody's going to bring an explosive onto a, at least not unknowingly. Lots of negligent people are not going to do that because they know they're not supposed to. They're not going to bring explosives onto or fireworks onto a train platform. But the other options when used, it's almost magic. This part of the narrow by actually goes below that. So this part is actually below this, okay? But if you just go to, if you click on Shepherdize when you're at a case, you can narrow by treatment. Treatment would be caution, positive, neutral, and that kind of a thing. But then you can also look at jurisdiction. I skipped that. Jurisdiction would be like, I want to see whether it was cited by federal courts and other state courts. If you want a home state, whether your home state used this case, you can confine it to your home state jurisdiction, okay? Basically, I'm teaching you some research. The other thing is you can pull in on this timeline. You say, I don't want cases going back that far. You can pull this little thing closer to us, or you can type in dates here. Or you can use this little icon over here to do it. But a lot of times you just grab a hold of this with your mouse and pull it over until you're satisfied that you have narrowed enough, okay? Not super hard, but fun. This is where Lexis gets to be fun. And you don't necessarily, I want you to do stuff for class that you feel like you don't have time to learn on the job, but when you're on the job and something difficult comes up, you say, hey boss, I already know how to do that. I can get it to where we don't have to look at we don't have to look at 2,000 cases, 1,800 some cases. We can look at, like, I'll narrow it down to where we're only looking at 5 or 10. That's when it gets fun. But will you have time to learn it when you're on the job? Maybe not. So learn it now and enjoy it when you have time to do it in class. If you lose track of what I told you too, don't forget that the Lexis reference attorneys can help you, okay? They're really, really smart about using their own stuff. They are like super smart. If you know what you want, you say, well, my instructor said something about shepherdized and then narrowing. What was that? I don't want to look at that many different cases and just scroll and scroll and scroll forever. Can you help me narrow it to present time or my state? And they can do that in like 2 minutes if they know what you want. They're really, really good. Tort law is very old. It grows by case decisions. Legislatures are reluctant to tamper with it, except limitations on specialized duties. When in doubt, ask how you would deliberate with dozens of people about who wins this kind of civil lawsuit. Here's the exceptions. Legislatures will give time limits on when the lawsuit can be brought. And I explained that special duties, they can create special duties, like legislatures or Congress plus regulators can create special duties. Can make things safer. Regulate companies, okay? How's that? Why bring this up now? The reason I brought it up now is that students mixed up statutes and limitations with substantive torts. They cited a limit as if it were the substance of the tort. In other words, they looked up negligence and they found how fast negligence cases have to be brought in your state. And they thought that was the definition of negligence, and of course it's not. Some confuse criminal statutes with torts. So don't start with that. Realize that most tort law is judge-made law, and don't expect to find it all in statutes. So I'm trying to set the expectations accurately. So here's like a limitation. This basically does not explain this type of tort. It just explains how fast you have to bring it. That's the end of my organized presentation.